All right, this is the next video lecture. This video lecture is on chapter 13, which deals with physical evidence. So physical evidence is material or tangible objects that are used in a criminal trial. So examples are guns, knives, blood-stained clothing, a latent fingerprint, or photographs. There are two types of physical evidence. There is real evidence, the object itself, and then there is demonstrative evidence, which is a representation of the real evidence. It's a copy, a model, a reproduction, an imitation. And we can think that certain times it's not feasible to actually have the real evidence there, so a model or reproduction might be a better fit. As with all evidence, physical evidence needs to be relevant, to be admissible. It needs to have connection to the facts of the case and the issues of the trial. Again, this falls back to that test in Federal Rule of Evidence 401, defining relevant evidence, and Federal Rule 403, which requires that that relevant evidence needs to not be prejudicial, but mislead the jury or waste the time. Now, when an attorney wants to use a piece of physical evidence, before it can be used in trial, before it can be admitted, there needs to be enough proof present to satisfy Federal Rules of Evidence 901, which requires that the object be what the proponent claims it to be. The proponent here is the attorney who wants to use it. So this requires authentication, identification, and is done through laying the foundation for the object. So examples of ways that you can lay the foundation for that tangible physical piece of evidence. You can have a witness testify who has firsthand knowledge of what the evidence is. You can have a non-expert who's familiar with the person's handwriting testify. This person does need to have not gained the knowledge of the handwriting for purpose of litigation. So it's just like somebody in the community that has regularly observed the writing. You can allow a jury or an expert to compare an object to an example and decide its authenticity. Distinct characteristics and circumstances may exist, such as sending a bill to an address and receiving payment from a bill. And voice identification can be learned firsthand or through an electronic transmission. There are some types of evidence that are self-authenticating. These are certified public records, domestic public documents, foreign documents, and official publications like books, pamphlets, newsletters, and periodicals. The burden of authenticating physical evidence in criminal courtrooms almost always falls upon the law enforcement officer. The types of physical evidence used in criminal trials are almost always discovered while investigating a crime, and the officer knows how the object connects the accused to the crime. Furthermore, the officer can be aware of the object's connection to the case because they frequently removed it from the suspect themselves at the time of arrest, or the object was taken from the crime scene. So they are oftentimes the best person in a criminal trial to introduce the evidence. So in order to have this object admitted into evidence, the prosecutor will need to prove that it is connected to the facts of the case. The prosecutor usually takes these steps in order. They will mark the object with a number, 1, 2, 3, 4, 10, up to 10, or however many pieces of physical evidence there are. They will lay the foundation for the witness to identify the object, and then they will offer the object to the judge as evidence and request that the judge accept it into evidence. Now, a defense attorney might take this opportunity to argue that this piece of evidence is unduly prejudicial or inflammatory towards the defendant. The person who collected the evidence is biased towards the defendant and falsified it. The object is not relevant or has not been positively connected to the case. and the officer cannot positively identify the object as the same object recovered at the scene of the crime. Now, for here, really quick, think way back to the very first chapter and topic we covered this semester, which is the chain of custody. So this is coming right back in here is very important for a police officer to make sure that they can positively identify that evidence, because if the chain of custody is not broken, it can be confirmed that this is the object that was removed from the crime scene. So just kind of a quick chance to tie that back together. Sources of physical evidence. Physical evidence can be found by law enforcement in multiple places, and it can be used to determine what crime has actually been committed. It can lead to other evidence. It can enable reconstruction of a crime or assist in convicting a perpetrator. At the crime scenes are the most logical and likely place. Other places, though, include the perpetrator's person, their vehicle, their home, the place of business, or bases of operation. So, types of physical evidence. There are fruits. So this should be a little bit of a review, but fruits of a crime, which is property that's seizable by a police officer. We're going to use the same examples as we used before just to reinforce. So, stolen or embezzled property. Instrumentality of a crime, which is the means of committing a crime, so like a gun or a knife. Contraband is material that is illegal for a person to possess, drugs, drug paraphernalia, certain types of guns. And then there's evidence of a crime, which is any object that demonstrates a crime has been committed. So again, we're reaffirming this idea from way back at the very beginning of the semester, the chain of custody. So when the prosecutor is going to introduce this evidence, it's their burden to show that this is the same and that it is in the same condition or substantially the same condition as when it's collected. So the prosecutor needs testimony that establishes that the chain of custody was not broken. The persons who are usually involved in possession are the collecting officer, a transport officer who may take it to a crime lab or for analysis, or even just the person who drives the evidence to the locker. Crime lab personnel, custodians of the records, and an officer who takes the object to court. So at the crime scene itself, the crime scene does need to be secured. So law enforcement have an obligation to protect the integrity of the crime scene, determine if anyone is injured or needs medical treatment or needs a healthcare professional, determine who is going to be interviewed, and as a byproduct, move those non-essential people out and close off the area to anyone who's non-essential. This will permit the collection of physical evidence. This can be intact, pieces of an object, blood, glass, liquids, fluids, and everything that is collected needs to be first collected, marked and tagged. It then needs to be packaged in transport, and then it needs to be stored properly to be admitted later on. Objects that are the fruit, instrumentality, or evidence of a crime or contraband can be introduced into evidence and exhibited to the jury, meaning the jury can view it or see it themselves, if it is proven that the object is related to the crime charged. And so to do this, there needs to be at least one person who is in a position to testify that the object is connected with the crime or it was found at the scene of the crime. This is, again, a repetition of the typical chain of custody, so we're not going to repeat that. And when to ensure that something is admissible at trial, there are 3 different ways to identify an object positively, which, remember, it's going to be required to get that in there. Officer can keep the object in their complete and exclusive custody and control from the time it was found until it's presented in court. An officer can maintain a complete and accurate record of the chain of custody, or they may mark or tag the object in some distinctive manner. So the chain of custody is going to be a pretty common method here. This method is used more frequently for financial type crimes. So like if you're trying to track counterfeit money or things like that, you might want to make it distinguished. Exclusive control is really impractical because it is nearly impossible for an officer to maintain possession, and they would have to maintain possession of many different objects. Furthermore, if an object required, it would not be under this mechanism. You cannot let experts analyze it, and the defendant would not have the ability to discover it. Chain of custody, again, we've talked about this a few times now, even multiple times during this video. So chain of custody is the more common mechanism. So let's talk a little bit about marking an object. Officers who discover and mark an object, they need to be able to mark in such a way that they can recognize the mark at a later date. Often there is a lapse of time between actually collecting and marking the evidence and its production in court. So they need to be able to, the officer needs to be able to testify that it's that this is the same object, and the marking needs to be distinct enough that it can be done. Marking objects is time consuming. A lot of objects are difficult to mark, and some objects should not be marked. So if it's impossible to mark it, then the officer should place it in a paper or plastic bag or container marked for identification. The marking should not interfere with the ability to perform a scientific examination if need be. And additional information like an evidence tag should accompany the object. So what goes on this evidence tag? Case number, name of the defendant, name of the victim, the officer who found the object, date, time, place where it was found, and a brief description. Also on this tag should be signatures of the person who found it, persons to whom the object was released, and reason why it was released. So like if a prosecutor came down to actually look at it, they would sign it out and sign why. And the ultimate disposition of the object. Physical evidence is frequently stored, and there have been cases where there have been problematic storage methods. So objects should ideally be stored in a way where they're going to retain their original shape and appearance as much as possible. Physical evidence, whether or not it can be mailed, it can be mailed. These are the recommended steps for actually mailing it. Now, preparation of physical evidence to be used in trial. Physical evidence can be extremely helpful for a prosecutor and law enforcement to present to a jury because it enables the jury to actually see everything and place themselves there. When physical evidence is admitted, the jurors do take that physical evidence with them while they're deliberating to help them recall the testimony of the investigating officer. Now, in some courts, whether or not an object is gruesome or not will impact the ability. The judge will weigh the impact that this object might have on the jury. Now, evidence would be admitted unless it is prejudicial to unless it is so prejudicial to the defendant that it overcomes the value of the evidence to the jury in overcoming the outcome of the case. In past cases, State v. Thompson, photographs of homicide victim were admissible at trial, even if they are gory, gruesome, horrible, or revolting, as long as they are used by a witness to illustrate their testimony, and so long as an excessive number of photographs are not used to solely arouse the passions of the jury. So some photographs are okay, but you cannot overwhelm the jury. Videos of crime scene or corpses. Under the Federal Rules of Evidence, the term photograph would include a video. An improperly authenticated video is generally admissible as long as it's relevant. All jurisdictions allow videos of a crime scene, even though they can often be gruesome. Now, just because a physical piece of evidence was collected and went through the chain of custody does not obligate the prosecutor or defense attorney to enter that piece of evidence into evidence, to introduce that piece of evidence in court. Again, just remember, we don't want things that are going to be overly cumulative, and that we can't, it's not acceptable to introduce every single photograph that was taken of a body. So not every piece is going to come in. The prosecuting attorney is going to have the final say so on what evidence is presented and how it's presented. Now, it is possible for a judge to permit the jury to view a crime scene. This is always going to be balanced with the amount of time it would take to view the crime scene and the value of viewing the crime scene. The trial judge would have control over how the viewing is handled, and they answer questions posed by the jurors and asked of the attorneys. So it is possible. It's not very common. Usually would be permitted if there's a really unique aspect to the crime scene that cannot be adequately portrayed. Otherwise, it's when possible, a reproduction or things are going to be preferred because they don't require moving all the jurors to a new location for a little bit of time. All right, this wraps up the slides for this chapter. Please let me know if you have any questions or thoughts.